This is from Frankolicious. That's a cool name. It says, client won't pay unless we agree to new terms after delivery. What are our options? Okay, this is a bit of a long one, so I'm only going to read part of it. I'll read the TLDR. We delivered a project to a U.S. company. They used and accepted all the work, but now refuse to pay unless we sign a retroactive contract with one-sided, non-compete liability and IP terms we never agreed to. They claim U.S. law or international policy prevents them from paying without a signed contract. We are a small international team. What are our options? Oh, man. Okay, let me read a little more into this. We did not sign a formal contract up front because we were transitioning. Once delivery was complete, they said they could not pay without a fully executed contract, citing U.S. legal and tax compliance requirements. We provided an agreement that accurately reflected the work. We even adjusted payment terms in their favor. They rejected it and sent their own contract. One-sided liability terms, an IP clause that could apply to independently developed tools. We suggested reasonable changes to reflect what happened. They refused. Now say they do not have time for negotiation. Will only process payment if we sign. Okay, no, just no. Actually, A. Taylor Orm says, "How much money are you talking about?" That's actually a very good point.
Right.
If you're talking about a couple of $1,000s, you're out. You're probably not gonna collect it.
Yeah.
If you're talking about $100,000, then yeah, man, this is. But let's just talk. Forget about the money for a second. I know it's easy to say, hard to do, but forget about the money for a second. Let's just talk legalities. I can't think of any reason, overseas or not, unless you're in one of the countries that we're not allowed to do business with, right? Like Iran and North Korea and such. Or if you had some type of, well, no, it would be coming into the United States, so it wouldn't matter. So the other thing doesn't matter. So no, I don't see any reason why you couldn't use your own, as we say in legal word, your own paper, your own contracts for them to sign. They want you to sign this one, and it's one-sided and it's retroactive. Absolutely not. You have a contract with them, whether they like it or not, and it doesn't have to be on paper. You did a service. They agreed to a price. Now, that's where it can get messy, right? Because they'll say, let's just use arbitrary numbers. They'll say, we told them 20 grand, and you'll say, no, we told you 100 grand.
Yeah,
and
but
that's where
he's saying they have most of this documented
that's
in
what I'm saying.
emails. And
That's where emails and things like that start coming into play. Text messages, voicemails, all that stuff starts coming into play. Because outside of a written agreement, then courts would look at, or a fact finder, if it's arbitration or whatever, would look at your other documentation to try to piece together what actually happened.
Was there a scope agreed on? Right?
Yeah, this whole, my guess is what happened was whoever contracted with you to do this or contacted you originally to do this was supposed to get their contract signed with their company and didn't do it.
Could be.
And now, because they didn't do it, is a guess, I don't know, but now because they didn't do it, they can't submit it to accounts payable because accounts payable has to have a contract, that contract approved by management,
by legal,
right? By legal, and because they can't get that contract approved because they never signed it, they can't send it over to accounts payable.
Could be.
That person is, or that team is likely what's actually the problem here. I would never recommend, in a million years, I would never recommend signing a contract retroactively. No. Unless you're comfortable with the language. Now, they said that this guy said that they provided their own contract with all the terms and everything, and were comfortable with it. Okay, that's fine. If you want to do that, you can do that. But you already did the work. They've already accepted the work. Technically, the contract really doesn't do anything. So here's what people don't understand about contracts. Contracts require a few things. Right? We say offer and then acceptance, right? Are the two things that have to be in a contract, right? But then there's the third thing that's incredibly important, right? And that's what's called consideration. Consideration is, what are you getting out of it and what am I getting out of it, right? I can't have you sign I can, but it won't be effective, sign a contract that you're getting nothing out of. It doesn't, there's no point, right? A contract is because both or all parties involved in the contract are getting something out of it,
Right.
whether it's money or service or a product or something, right? It could be time, it could be anything, right? It could be I'm signing this contract because if I do, you won't sue me for something. It could be for a variety of things, but you have to get something out of it. You've already provided the work. Now the people might say, well, if you sign it, we'll pay you. You're already entitled to that money.
Right.
Now, if they want to throw a cherry on top, another $1,000 or $5,000 on top to sign this contract, that would be consideration.
Right.
Right. But absent something like that, you've already done the work. So even signing this contract retroactively, I don't know that that would have any play because you already did the work and gave it to them.
Right.
You just haven't been paid.
It's completed.
Exactly. The contract
has been
fulfilled. No, actually the contract's not completed because you haven't been paid.
Right.
You completed your portion of the contract.
They
now need to complete their side of the contract.
That's really the only thing missing from making this contract
asking
delivered.
you to sign a contract retroactively, number one, I don't know would have any effect.
No.
It might, but I don't think so. And number two, it's not necessary. You've already done the work. You should have now. Your fault for not memorializing it in a contract beforehand.
So let's answer the question.
I thought I did.
No. Can this debt be assigned or enforced? Right.
Can this debt be the debt? Is that what it says?
Yeah. So,
okay. Yeah. Can
so
the debt be
he's
assigned
basically
or enforced?
asking, is there a way for them to collect it?
Well, yeah. You could take him to court. You'd have to take him to court in the United States. In whatever state and county they're in.
Correct.
Right. You would have to take them to court there. You'd have to show that you had a contract. And again, contract can be verbal or written. It doesn't matter. But you'd have to show that you had a contract for work. And if it's not a written contract, then you can bring in these ancillary documents, the emails, et cetera, et cetera. And a judge or an arbitrator or whatever would put the pieces together and say, in my opinion, the contract was for $85,000 and you were going to deliver X, Y, and Z. Okay. Did you deliver X, Y, and Z? Yes. Show me. They're using it on their platform right now. You can go online and see it.
Yep.
Okay. I think you delivered it. Did you pay them $85,000? No. Why not? Well, they didn't sign a contract. It doesn't matter. You owe them $85,000.
Correct.
Now here's the problem. That's step one.
Yeah.
And I hate to say it, that's the easier step.
Now you got to collect.
Now you got to collect it. Right. And this happens all the time. People think, hey, I got a judgment. I'm going to get my money.
Nope.
I can't say with certainty. I probably should look this number up. But if I had to guess, I would say 80% of judgments are uncollectible, if not more. And what that means is you go through the trouble of hiring an attorney. You get you go to court, spend years doing that, travel time back and forth, travel costs back and forth, and you finally get your judgment. You may be in 40, 50, 60, 100 grand, but you got your judgment. You might never be able to collect on it.
Right.
And that happens, like I said, probably 80% of the time.
So what would need to happen in order to collect it next?
So so let's say the judgment's against a company.
Yep.
Okay. You have to know where that company banks. Sometimes that's easier than it's if they ever wrote a check to you, well, you know where they bank.
Right.
Sometimes you can send a discovery request demanding that they give you information. If they don't give it to you, then you can file a motion with the court to compel, and then the court will enforce it. And if they still don't give it to you, then they're going to sheriffs are going to show up and they're going to arrest some people.
Okay.
So that really compels, right? So then you get the information about their bank. All right. So now that you have that, you can file what's called a writ of execution to go to the bank and say, hey, Mr. Bank, we have this judgment. And the court signed off on a writ of execution, freeze their assets, right? And then pay us whatever's owed out of that bank account.
Right.
Here's the problem. What if there's nothing in it? What if they owe you 85 grand and there's 10 grand in there?
So before you even start thinking about going this route, you have to know whether or not it would be feasible for you to even chase it down.
Yeah, exactly.
It's just kind of what I wanted people to know, right? Because
I know.
like if you are owed $1 million by a shell company, right?
You're not getting it.
No.
Judgment isn't worth the paper it's written on.
Correct. But if you have a judgment against a Fortune 500 company, now you have something to go after.
Right. Yeah.
Right. Like, so you have to understand who you're trying to get money from. Because like you can't get blood from a stone.
Yeah.
Right?
And this happens, unfortunately, all the time in the home improvement contractor world.
Oh, yeah.
Right. Where the contractor will start an LLC, go out, collect a bunch of deposits, either not do the work or do the work horribly or maybe half the work or something like that. And then the person sues. The contractor doesn't bother answering.
Nope.
They win, the homeowner wins, and then they go to try to collect, and the bank account's been shut down. They're the place where they went before, the lease is vacant.
Yep.
And there's nothing to get from anybody.
Yeah. It's we always hear about someone not paying contractors and contractors having to collect.
Yeah.
Very few
Which
people.
is true.
Correct. It happens a lot too, but this happens more than people realize too. Is someone, I was reading a story about this the other day. Someone collected like $500,000 worth of deposits.
Yeah. Yeah.
And it was a shell company and it basically disappeared.
Just walked off with the money.
Yep.
I know. It's really a shame. Now, Pennsylvania and now recently Jersey as well has done stuff to combat that. They passed what's called the Home Improvement Contractors Act. So it's a whole act dedicated to just protecting the homeowner from things like that. But not every state has that right now. So not that we're talking about those things, but again, collecting on a judgment, it's a lot harder than people think it is.
Yeah.
They think, oh, I got this paper, I'm getting my money. No, you're not. Nope. No, it doesn't mean you're getting a thing. It just means you have a judgment. And maybe down the line somewhere you'll get your money, but maybe probably not in many cases. So anyway, Frank Delicious, I'm sorry to say, number one, don't sign. I would not sign that contract. Number one, especially if it's not in your favor. And number two, honestly, you might want to reach out to someone else in the company, contact their CEO or contact their COO or something, or even their legal team and say, look, here's what happened. I'm guessing, and again, this is just a guess, I'm guessing that whoever you were working with did not get the contract signed like they were supposed to, and therefore it can't be turned over to accounts payable.
Yep.
That's my guess.
And they could have issues with, it's that conversation, let's say it's code.
Yeah.
Who owns the code? Right. And the legal team may have said, well, this was meant to be proprietary for us. We don't want someone else getting it.
Right.
Well, the software developer could have used it 5 times before.
It doesn't matter. Right? You don't have a contract. Doesn't matter.
Right. So
that's like not your fault.
There could be all kinds of things going on behind the scenes that you don't know about. So yeah, it's worthwhile reaching out. Like send them an official bill.
Yep.
Start with that.
Yeah.
And like send it.
Just send it. Maybe
in the mail, not email.
Yeah,
send it in the mail, and see who gets back to you.
Yep,
right.
It's true. I like that idea. Send it in the mail.
Yep.
I like that. That's good. All right, so Frank Delicious, good luck to you. We hope the best.
If you found this clip interesting, make sure to go listen to the full podcast. There's lots more content there.